SJC-11609, the First Marblehead Corporation v. Commissioner of Revenue.
Welcome back. You may proceed, Mr. Abrams.
May it please the court, Don Abrams for the taxpayers here. Since this is a return trip, I'll be very brief in setting the case up. Gate Holdings is a financial institution. It has no regular place of business, but it has a Massachusetts domicile. Its only material assets are minority and majority equity interests in more than a dozen trusts, securitization trusts, that are treated as pass-throughs for income tax purposes. Their only assets, in turn, are tens of thousands of student loans each. All of those loans are serviced by out-of-state, unrelated professional servicers, principally by the Pennsylvania Higher Education Assistance Agency, or FIA, which is a Pennsylvania governmental agency that's one of the top 5 student loan servicers in the country. The issue in this case is whether the commissioner can reassign those loans for property factor purposes 100% to the numerator of Gates' Massachusetts property factor in apportioning Gates' income under the financial institution excise. The clause that the commissioner is relying on is Chapter 63, Section 2A, 6B. That section, or that clause, establishes a rebuttable presumption. And under that presumption, it is assumed, unless the taxpayer can rebut it, that the preponderance of substantive contacts are at the place of commercial domicile if the taxpayer assigns the loan to a place that is not a regular place of business.
Is it possible to have more than one commercial domicile in your view?
Not to my knowledge.
But your brother wrote, as I understand it, to say it's internally consistent because if every state had our test, you would be domiciled only here and therefore could not pay more than 100%.
And the problem with his analysis is that he didn't read the entire statute. What the statute says is that any loan assigned by a taxpayer outside of the Commonwealth that is not a regular place of business will be presumed to be in the Commonwealth. The way the commissioner is interpreting it is the equivalent of any loan that is assigned by a taxpayer to a place that is not a regular place of business, because the commissioner is assuming that this statute is symmetrical, that it can assign loans that were assigned in-state to a commercial domicile out of state or out of state into the state.
I lost you.
I'm sorry, let me say that again, or try that again more clearly. The statute says, in the case of a loan which is assigned by the taxpayer to a place without the Commonwealth, that is not a regular place of business.
The first clause would treat it as the Commonwealth loan. It is in the Commonwealth, right?
No.
Doesn't A say if it's...
No, not at all. What A only deals with loans that are assigned to a regular place of business of the taxpayer. I think we all agreed after our first visit here that there is no regular place of business here.
I understand that.
So Clause A, by its terms, only deals with loans where there is an assignment to a regular place of business and then a testing as to whether that assignment was correct. B is the only clause that deals with loans that are not assigned to a regular place of business. And it's an asymmetrical statute. It's a one-way street. It only will assign loans to commercial domicile if the taxpayer assigned them outside the Commonwealth to a place that is not a regular place of business. By its terms, Clause B does not apply to a loan that the taxpayer assigned within the Commonwealth to a place that's not a regular place of business. So to take an example that brings things into focus, but is not our facts, if you had an out-of-state taxpayer, an out-of-state trust, maybe based in New York, otherwise just like Gate, and if that taxpayer hired the Massachusetts Educational Finance Agency as its servicer, and that taxpayer looked at the entire framework of the statute, the mirror image statute that it presumably has in New York and that it has in Massachusetts and maybe it has in the other 48 states. And in every one of those, they said, look, I got a 25-year loan. There's going to be contacts with the borrower on my behalf by the servicer for a quarter of a century. If the borrower sends them money, that's treated as payment to me, that under the trust documents and the servicing documents, and by the same token, if the borrower gets in trouble and the servicer gives a forbearance, that's binding on me because that's in the servicing arrangement. So the taxpayer looks at that and he says, I've got a statute that looks at the activities with respect to the loan, the facts and circumstances. I think that belongs in Massachusetts with the Massachusetts Educational Finance Agency.
Didn't you have to prove that that your client had a regular place of business in Florida that had the predominance of the substantive contacts with the loans in question?
We needed to prove that, yes, under a Massachusetts mirror statute, in other words, not that Florida's actual statute, that's irrelevant.
And
but
did you present evidence on that point?
We presented evidence that the loans were handled by the servicers. We presented evidence that the servicers' receipt of payments was considered binding on the trusts, on the owners of the loans here, that the servicers had the power to grant forbearances, that in most of the loans, the servicers were...
That's a different question than the
I'm not sure...
Commerce Clause.
I'm not sure it is. In other words, getting back to the Commerce Clause, what we're trying to prove, and I think this is what Justice Spina was asking, is the statute symmetrical? So in the example I was going over with you, Justice Botsford, the taxpayer who had assigned the loan to Massachusetts, looking at the statute, the only technique for getting that loan out of Massachusetts, if it was a taxpayer like Gate Holdings, would be under Clause 6B, because that's the only clause that deals with loans that are not assigned to the location. And under 6B, if a loan is assigned to the Commonwealth, it can't be thrown out of the Commonwealth.
So if the taxpayer makes a mistake, the taxpayer is up the creek without a paddle. Is that what you're saying? If the taxpayer mistakenly assigns a loan here, that's too bad.
Is this taxpayer domiciled in New York, did you say?
Yeah, for purposes of our discussion, I flipped it around to show you, to illustrate how the statute would need to be symmetrical. So a taxpayer domiciled in New York who had assigned a loan to Massachusetts because it was being serviced by MIFA.
That's a mistake under
well,
the way...
It's only a mistake if you assume the answer. That, with respect, that's begging the question here. The purpose of 6B is to test whether an assignment was a mistake. If it is a mistake, the loan is thrown back to commercial domicile.
Right.
But until you get to 6B, you have no reason to think it's a mistake. You've got a statute that says source to where the facts and circumstances are, the activities relating to the loan. For a quarter of a century, that loan is going to be serviced by the servicer. The taxpayer makes that judgment.
But that argument is that where, I think, it's a different question, which is where that the servicer should be counted for where the loan is located, which is an argument that we rejected, but I didn't think that's what the Supreme Court was interested in.
No, that's not what they're interested in. What they are interested in, I'm sure, is that the statute is asymmetrical, that a loan that has been assigned to Massachusetts cannot be thrown out of Massachusetts, but a loan that has been kept out of state can be brought into the state.
Do you essentially adopt the position of the professors who are amici?
The professors who are amici, in many ways, took our argument and inverted it, which is appropriate because the statutes are supposed to be symmetrical. So, yes, to the extent that a loan is assigned to Massachusetts and can't be thrown out of state, The statute is asymmetrical. It fails the internal consistency test. It's not a mistake to assign a loan to a location in good faith. That's what Section 6B is all about, is testing that assumption to see whether it is proper or not. If it's not proper, you're back to the presumption. But it's not a mistake to assign it. Clause B may reassign it if it's constitutional and symmetrical. It may reassign it. But the taxpayer, the way the statute works is in the first instance, the taxpayer makes an assignment, presumably in good faith. It is then tested. 6A, no, that doesn't apply because there's no regular place of business. We look at 6B. 6B says, look at all the facts and circumstances, make a judgment. If the taxpayer doesn't carry a burden of proof, which is important for the commissioner because it relieves him of a lot of duties, if the taxpayer doesn't carry a burden of proof, then the loan comes back to commercial domicile, but only if 6B applies. And the way 6B is worded, it only applies if the loan was assigned out of state. It's a one-way street. To make it a two-way street, to make it constitutional, you need to read those words out of the statute.
What words?
The words to a place without the Commonwealth. So you'd need to read the statute as if it read, in the case of a loan which is assigned by the taxpayer to a place that is not a regular place of business, wherever they assigned it.
Okay, thank you.
Thank you.
Brett Goldberg for the Commissioner of Revenue, and may it please the court. I think Justice Cordy focused on exactly the problem here, which is that the taxpayer did, taking this court's interpretation of the law, that this taxpayer, if it would have then assigned loans to any state other than Massachusetts, would have been making a mistake. It would have been misinterpreting and misapplying the law.
Well, it could have, I think you would say, it could have proved that the servicers were in fact agents of the, of Gate.
Well, but this court already rejected, I think.
No, I'm just, this is all hypothetically. I mean, it could have done that.
It could have proved that the services were agents of Gate, and
In which case, the assignment to wherever would have been okay, right?
Had it done so.
no,
Had it done so. I'm not saying it did, I'm saying had it done so.
Or that we're not saying that it has the ability to, or it had the ability to do so. We're saying on the assumption that it had the ability to prove that the servicers were in Pennsylvania and that they were agents. Had it proven that, then the assignment would have been correct.
I'm perhaps misunderstanding, but this court was quite clear, I think, in the
This is
first
a
opinion.
hypothetical.
It's a hypothetical.
I know, but the hypothetical supposes that agency could count as giving a taxpayer a regular place of business, and the court rejected that proposition. Agency cannot give the taxpayer a regular place of business. The opinion was clear that only by through its own employees at its own regular place of business.
It was your argument below. I mean, it was your argument that they hadn't proved agency. But I thought your position was that agency would have been something that was available to be proved.
That was our position below. The court rejected that in its first opinion, and I was adopting the court's interpretation of the statute and then asking the question on the remand, is the court's interpretation of the statute internally inconsistent? If you want to revisit the agency question, then I'm happy to engage in that hypothetical.
Okay.
So then let's try and get that clear. I'm sorry. If agency had been enough to establish a regular place of business in this case, Pennsylvania, then the loans would be properly assigned to Pennsylvania.
I guess the agency comes under the fifth factor, right? Administration.
No, agency is,
Well, I mean, that's where I was thinking about it. But
well, the fifth factor is the only factor that's relevant to the case because it's clear that
Right.
Gate was not engaged in solicitation or negotiation or any of those other factors. But the agency, the theory of agency, that it might give a regular place of business.
I appreciate that you need a place of business, so, go ahead.
Well, it seems to me that as the law is interpreted by this court, or if it's interpreted a different way, if agency is presumed to give the possibility of a regular place of business in another state, then the assignment is either wrong or right. If it's a mistaken assignment, the taxpayer isn't stuck with it. It would be a misinterpretation and a misapplication of the law for the loan to be assigned in the state where it doesn't belong. You don't need a presumption, you don't need the statute to tell you if the law is simply misapplied, that was a misapplication of the law.
May I ask you a question about a point in the amicus brief of the commission? It was stated that our statute is a carbon copy of the model statute, and I presume that it's been adopted by states other than Massachusetts. Is that right?
That is right.
Okay. So do you know how many other states have this same provision? And just to give me an idea of if this provision were to be deemed unconstitutional, what would be the broader impact of that? I'm just trying to assess that if you know.
I don't remember the exact number. My mind is, I'm thinking something in the teens of the number of states that have adopted this provision, but I don't know for sure. I can get that information for you.
Okay, and do you know if this precise challenge has been made to the statute in any other jurisdictions?
Not so far as there's been any reported case.
Okay.
We certainly looked pretty hard, and there's nothing like this being raised.
So this is the first time that you're aware of that it's been challenged on this particular ground?
That is correct.
Okay.
That is correct.
And what do you say about what the professors suggest is the right test here?
Their formulation of the test, I think, is another way to ask the question that's before the court. I don't have any problem with that. They say, well, suppose the mirror situation and Gate or a taxpayer like Gate is commercially domiciled in another state and then has no contacts with Massachusetts, has no regular place of business in Massachusetts, then what would Massachusetts do with the loans? And I think it's clear under this court's interpretation of the law that Massachusetts would not include any of those loans in its property factor numerator. And I think that's exactly the same result you get if you approach the question the way the Supreme Court does itself with the internal consistency test.
Say it's clear from our decisions?
Yes, I don't think there's, to me,
Which decisions could you point to saying that that's clear?
I think it's clear, what I'm saying is this court's interpretation of the law
In this case?
in this case
Okay.
implies, I think, without a doubt, that a loan can be assigned in only one place or another. It can't be assigned in two places. And Massachusetts would not include in its property factor numerator any of those loans if Gate was not commercially domiciled here and did not have a regular place of business here, because those are the only two ways that a loan could be assigned anywhere. It has to either be associated with a regular place of business by a preponderance of contacts, or if it's not associated with a regular place of business anywhere, then it's located in the taxpayer's commercial domicile. And those fact patterns are mutually exclusive. A loan can be associated by a preponderance of contacts with only one regular place of business, and only if it's not associated with a regular place of business anywhere could it be assigned or located in the taxpayer's commercial domicile.
Now here, they were claiming that the loans were assigned to Florida?
They, Florida does not have the same law as we do, but they do include in the Florida property factor, actually,
Well, that doesn't matter, though, does it? I'm sorry, that Florida doesn't have the same law?
well, the internal consistency hypothetical, of course, assumes that the law is the same in every state
As ours.
as ours.
Yes.
And then we see what would happen. You might ask under the hypothetical, if Gate did assign the loans to Florida, if they had our same law, what would happen? And I think the answer to that is that would be a mistaken assignment. That would be a misapplication of the law because there would be no basis for assigning the loans there in the first place.
Now, they would have to prove that they assigned them in Florida by showing that, that there was a predominance of contacts with the loans in Florida.
Well, the taxpayers are, and the commissioner have stipulated in effect for this case that assignment includes reporting it on your tax return. So we agree that they might have assigned the loans to Florida or any other state. In fact, they did report some of their loans in Florida in their property factor numerator. On their theory, they, I think, would possibly include their loans in many states in their property factor numerator.
Have you ever had a case where the taxpayer has actually had a commercial, where we are in the position, let's say in this hypothetical, of Florida? In other words, there's a taxpayer with a commercial domicile in Florida who Massachusetts is seeking to tax, where you have.
This is sort of the question raised by the professor's amicus, suggesting that possibly the court needs to remand the case for further findings. I've inquired, and I believe the commissioner has never taken a position different from the position we're taking here.
But, and you would say, let's assume this has never happened, but it seems to me the only consistent position you could take is that if the taxpayer who's been charged with taxes here asserts, and you accept the assertion that its commercial domicile is in another state, no way can you get any of that. It's going to be a zero property factor.
I agree completely. That's absolutely right. That's absolutely right, and that's what I'm saying. It's because of that exactly that is the necessary result under this statute, that the statute does not fail the internal consistency test.
How many of these phantom financial institutions do you have before DOR?
Oh,
No employees, nothing, just a phantom, just happens to own things.
I can't tell you, Your Honor. Certainly there's plenty of cases where holding companies are set up within a corporate group, and all they do is own some kind of property or another and pass money through to their parent or to their subsidiaries and don't really do any business in the ordinary sense. How many financial institutions fit that category? I'm sure there are plenty. I think that Gates' structure is probably not unique.
Okay, so this is not a singular circumstance to have a phantom entity.
We normally would.
It's sort of inherent in holding companies, isn't it?
Yeah, I mean, we do generally, notwithstanding that they're not engaged in regular operations, respect the corporate structure. That's sort of a very well-established tax law principle.
Okay, thank you.
Thank you.